Welcome, and thank you for joining us for our monthly webinar. I am really excited for today's discussion on the myth of the perfect victim, barriers to prosecuting sexual assault. My name is Rachel Marshall. I'm the Executive Director of the Institute for Innovation and Prosecution at John Jay College, and we host these monthly webinars. Please make sure to sign up on our list if you haven't already at prosecution.org. The IIP provides a national platform to bring together prosecutors, policy experts, and the communities they serve to promote data-driven strategies, cutting-edge scholarship, and innovative thinking. The IIP champions criminal justice reform policies that advance community-centered standards of safety, fairness, and dignity. Sexual and gender-based violence impact thousands of people living in the United States each year. Data from the National Sexual Violence Resource Center demonstrates that nearly 1 in 5 women in the United States have been victims of rape or attempted rape in their lifetime. The percentage of women who have been victims of sexual assault and harassment is estimated to be as high as 80%. Sexual and gender-based violence disproportionately also impacts LGBTQ and transgender people as well. Today's conversation with leading experts in sexual and gender-based violence will push back on the prevalent myth of the perfect victim and the deeply problematic barriers that this trope presents to prosecuting sexual violence. We will also provide prosecutors with specific guidance on how to improve victim services for survivors of sexual violence. It would be remiss if I didn't mention that today's discussion feels particularly timely in light of last week's decision by the New York Court of Appeals to overturn the convictions of Harvey Weinstein. Our panelists today will discuss the implications of that decision and the continued obstacles to prosecuting sexual assault cases. In the interest of time, I'm going to introduce our panelists and moderator very briefly, and we will place a link in the chat to their full bios, and we encourage you to read about their experiences and accomplishments. I'm going to start with County Prosecutor Jean Peters Baker, who was appointed prosecutor in May 2011 and elected to the position in November 2012. She's only the second woman elected to lead the Jackson County Prosecutor's Office. The first is now U.S. Senator Claire McCaskill, and who hired her as a young assistant prosecutor. County Attorney Baker has since served in nearly every unit of the office, including sex crimes and child abuse, community justice, domestic violence, drug enforcement, family support, major crimes, and as chief warrant officer. She is widely credited with being unafraid of tackling difficult cases. In 2011, soon after being appointed to lead the office, she prosecuted the Bishop of the Diocese of Kansas City, St. Joseph, for failing to report potential abuse of children by a priest. Welcome. Next, I'm delighted to introduce Anita Tika, who is Latino Justice's Chief of Advocacy and oversees the organization's policy and advocacy campaign work related to worker and immigrant rights, voting rights, criminal and economic justice reform, and issues affecting Puerto Rico. Prior to joining Latino Justice, Anita was the Senior Director of the Anti-Trafficking Program at Safe Horizon, the nation's largest victim services agency. She successfully, in coalition, secured passage of the START, or Survivors of Trafficking Attaining Relief Together Act, in New York, which enables victims of human trafficking to seek criminal record relief for convictions related to their trafficking, and has also supported multiple reauthorizations of the Federal Trafficking Victims Protection Reauthorization Act and the International Violence Against Women Act. Welcome, Anita. Next, I'm delighted to introduce Professor Deborah Turkheimer, who joined the Northwestern Law School faculty in 2014 after serving as a professor at DePaul University College of Law since 2009 and the University of Maine School of Law since 2002. She presently teaches and writes in the area of criminal law evidence and feminist legal theory. Her book, Credible: Why We Doubt Accusers and Protect Abusers, was published in October of 2021. Previously, she served for 5 years as an assistant district attorney in the New York County District Attorney's Office, where she specialized in domestic violence prosecution. And now it is my pleasure to turn things over to our moderator for today's discussion, Professor Michelle Dempsey, who joined Villanova in 2009 after teaching at the University of Oxford, where she was a university lecturer and law and tutorial fellow. Professor Dempsey teaches and writes in the area of criminal law, feminist legal theory, and jurisprudence. She has served as chair of the American Association of Law Schools section on scholarship and section on jurisprudence, and was elected to the American Law Institute in 2015. At Villanova, she teaches criminal law, evidence, jurisprudence, feminist legal theory, and sexuality in law. In 2014, she co-founded the Villanova Law Institute to address commercial sexual exploitation. Thank you, Professor Dempsey. I'm going to turn it over to you, and just wanted to note that we will take questions at the end of today's discussion, but feel free to put them in the chat throughout today's discussion. Thank you so much, Professor.
Thank you, Rachel, and special thanks as well to Chantel Williams, who's done so much to make today happen. I'm delighted to get to be a part of this and really honored to serve as moderator to a panel with such terrific people who have such deep knowledge about this topic. So I'm just going to dive right in, and I'll start with Professor Turkheimer. And just so people know, we agreed ahead of time we would go by our first names. So I'm going to kick it out to Deb for our first question. And just ask that you explain generally, sort of what is the myth of the perfect victim, and why is this notion so harmful? And then maybe you can give us a modern day example of how this sort of plays out in the realm of sex crimes.
Oh, absolutely. I'll very quickly say thank you to everyone. It's an honor to be on this panel, and I'm so pleased to be having this conversation. It's important and it's very timely. The myth of the perfect victim, it has maintained its hold on the popular imagination. I think it stems from the paradigm of stranger sexual assault. And the idea here is that victims of stranger sexual assault behave in a certain way, and all victims then behave in that way, goes the myth, and they should behave in that way. So when behaviors depart from kind of the mythical perfect victim, we tend to have real problems with seeing that individual as a victim. So I'll give some examples. I think that these behaviors really do pertain to what happens before, during, and after an assault. Before, I think we can bracket. I think we'll come back to that later on in our conversation. I'll focus on sort of during and after right now, because I do want to talk about the modern day example to answer your question. And that modern day example is the case of Harvey Weinstein and the overturned conviction. We'll just get right into it. So what does the perfect victim do during an assault? She fights back. We all know that resistance is kind of deeply baked into our formal laws as a historical matter, and the expectation of physical fight, I think, has persisted. So during an assault, the perfect victim fights back. After the assault, she reports immediately. She, of course, cuts off all contact with her abuser. Remember that this is the paradigm of the stranger assault. So there would be no relationship that was sort of ongoing. There would be no need to have contact. So the perfect victim has no contact with her abuser. She remembers everything perfectly. The chronology, the sequencing is precise. Her emotionality, and I'm using gendered pronouns, of course, men and folks who are non-binary kind of be victims of sexual assault. The victim's emotional affect is absolutely precisely calibrated to be just what we have come to expect. It's not overly emotional or hysterical, but it's enough emotional so that we believe that this actually happened. And so these are some of the ways in which kind of mythical victim behaviors distort what we come to believe in terms of how someone should present when the person comes forward with an allegation of abuse. So in the case of Weinstein, I think everyone can imagine that when prosecutors ultimately decided to pursue this case, it was after dozens of women had come forward outside of the court of law. The first time a woman came forward on her own, it was Amber Gutierrez, and her account of being assaulted by Harvey Weinstein went nowhere. There was no prosecution by the Manhattan DA's office. Years later, when there were these many women who had come forward, there was a prosecution. But of course, the assistants handling the case understood that they would be up against a whole lot when they needed to persuade the jury beyond a reasonable doubt. And for these reasons that I'm talking about, it became, I think, incredibly important, if not essential, to give the jury other women, not just the three victims who were victims of the charged crimes, but these pattern Molyneux witnesses. And so I'm connecting this to the myth of the perfect victim, and I want to be very clear why. Because jurors tend to have this myth still today, and to kind of persist in thinking that victims behave in certain ways, it's exceedingly difficult to convince them that when a victim departs from the sort of perfection, the ideal, that she's believable. And so there's all sorts of gravitational pull in the direction of this kind of corroboration, this kind of other evidence that ultimately proved to be, the demise of the conviction. So I think that's just something to get us started. I know we'll talk a lot more about all of this, but maybe that's a good way to lay out, at least at the outset, what we're going to be talking about.
Great, thank you so much, Deb. I'm going to shift now to County Attorney Peters Baker, Jean. Jean, I'm going to ask if you can explain the root of the myth of the perfect victim as it plays out in the criminal justice system. And in particular, how have you seen it play out within your work as a prosecutor?
Thanks for the question, and thanks for the setup. The setup of how victims are judged is still very current, I think. So what we require of victims, how perfect, and then they can't be too perfect. There's a very narrow window, I think, on any given day in front of a jury, what is going to be sufficient in these types of cases. And evidence is also a difficult problem when you get into courtrooms on cases like this. But that said, that being a real barrier for prosecutors, is that we have to have a perfect victim, but she can't be too perfect. That also must align with how difficult it has been legally to get these cases through our system. So, for instance, in my state of Missouri, you could legally rape your wife until the year 1991. That's not very long ago. So it literally wasn't a crime in certain contexts, for women to be raped. So think about how that very recent history, the long historical lens of how, what women's rights were, how we had to gain rights over time. It wasn't just a magical flip of a switch. And we all agreed women were entitled to these rights. It's been a very slow progression to get us to where we are today. And then it's still codified in laws that we still have to recognize. So, for instance, when I worked as an assistant prosecutor in the sex crimes unit, I learned that in cold hit rape cases where someone's DNA came back on an uncharged rape case, I was able to go forward with the charge. I would have to ask a victim, if it was pre-1991, because it was one of the elements of the crime, was she in fact not married to the individual that had been charged with raping her? Of course, she didn't know the person's name, so it seemed silly to do that, but it was part of the legal requirements that I had to prove. I had to disprove one of the elements that would have made it legal that they were in fact married. So I just say that because it's important for us to remember laws also made these cases structurally impossible at times, but it was also a setup to make it very difficult for women in particular. And I know I'm going to use that gender pronoun more often probably than I should, because I do know that this happens to men as well. But it seems so often that women are on the receiving end of this victim, so on the victimization, which is why I prefer that pronoun, but it's not to the exclusion of men as victims. So anyway, what I will say is that the law has structurally, added to this view of the perfect mythical victim, what must be required, that it was a stranger, that it had to be, she had to be particularly injured to prove that she fought back sufficient enough. Whether or not a gun was present or not, and all of those types of factors, rather than just the differential in power and how cases may come together just from that interplay of who had the power in that particular fact pattern to to cause this crime to occur in the first place. So, you know, Missouri is not different. We went with the rest of the nation on this particular topic, and maybe we're a little slower than some to get to, a greater rights structure for women, but that still persists. That legal background still persists.
Thank you, Jane. Thank you. So I want to move on now to Anita Tika. So Anita, you bring such a valuable perspective to this conversation because you're working directly with survivors, with victims as their advocate and not as just the prosecutor on their case. And so I'm really eager to get your views and to see if, in your perspective, how do some of these mistaken beliefs and the tropes around the myth of the perfect victim impact a victim's own view of their sexual assault?
There's so many ways to answer that question, and I want to thank IIP first for convening this panel and talking about this really important topic with these amazing panelists and with Michelle. And so my former program, the anti-trafficking program, we worked with all genders. We worked with folks from all backgrounds, including sex trafficked individuals, including male identified individuals, or those who experienced labor trafficking, who had also experienced sexual assault during the course of their trafficking or during the course of their exploitative employment. And given what Deb laid out as the concept of the myth of the perfect victim, that you fight back during the assault, that you report right away, that you have a certain kind of background, that you present a certain way when talking about the assault, that you're emotional, but not too emotional, you're upset, but not too upset. We had clients who, especially if they knew the person, they felt that they played some role in their assault. You can't be a victim. You can't consent to being the victim of an assault, right? You can't consent to being the victim of a crime. And so I would have prior clients who really put so much of that blame on themselves. They would believe that it was their fault. And because of that, they oftentimes wouldn't want to report that part of it to law enforcement. They would report other things that they thought were less stigmatized to law enforcement. So they would report if they had wage theft or if they had non-sexual assault related crimes against them, but they wouldn't necessarily want to talk with law enforcement about reporting the sex related crimes aspect of it because they felt their credibility was going to be called into question, because maybe they didn't fight back, because maybe it was their employer who was perpetrating the sexual assault and they didn't think they could fight back, or they were being threatened, or their family was being threatened. And so they didn't want to risk exacerbated harm to individuals that they knew, so they didn't fight back, or they were undocumented and they didn't want to go to law enforcement to report the crime because they didn't want to be deported. And so there's a whole host of reasons why individuals of all backgrounds don't act in this stereotypical way that we would expect someone who has experienced a sexual assault or a sex crime to act. Something else that I saw when I was working at the anti-trafficking program and with individuals now is there's such a shame and stigma associated with these crimes that often there's not full disclosure right away to service providers. So not even talking about prosecutors and telling your story to a bunch of jurors that you don't know in a courtroom that's embedded within a legal system that might be completely foreign to you, or whether you're from the United States or not. Our judicial system is an enigma to many, many people in terms of how it operates. But that shame and stigma can also carry over to how you interact in a guarded way or not with service providers. So what you tell your social workers and what you don't tell your social workers. We also had male victims who had experienced sex crimes who didn't share any of these details with their social workers because there's such a stigma depending on what their home countries were, what their cultural origin stories were, that they hadn't grappled with it internally as to what may have happened to them. And so if you don't have words for something, you can't articulate yourself to other people external to yourself, right? Another piece of it is trauma. Trauma can cause faulty memories. And so when we're talking about a victim's view of their own sexual assault, sometimes people don't remember all the pieces of their sexual assault because they've experienced such intensive and sometimes, unfortunately, pervasive and prolonged trauma. If there were a series of assaults or this happened over, a sustained period of time, that people don't remember all of the details. If you don't remember all of the details, you cannot report all of the details. And so then that calls credibility into question, which then plays into, well, if this person doesn't remember everything that happened to them, how do we know that anything happened to them? And so you have all of these pieces that are happening simultaneously where there's a lot of internalized blame, this external and internal shame and stigma, not wanting to report to law enforcement, and then looking at intersectional identities of what the person may be grappling with as to why they're not behaving like this quote unquote like perfect victim. If there's immigration status at play, if they have children, they don't want their children to know about certain things that may have happened to them or their partners. And then the context of when, where, and how the sexual assault may have happened. So it's very, very complicated, and it can really impact how an individual can move forward.
Thank you, Anita. That's really helpful. And it segues nicely into the next set of questions that I wanted to explore. The factors that you were discussing regarding credibility and how it's perceived by others and how it's sort of internalized. I wanted to turn to Deb to discuss your really fantastic book. And for everyone out in the audience, if you have not already read the book Credible, Why We Doubt Accusers and Protect Abusers from 2021, I highly recommend it. It's a wide audience read. It's incredibly insightful. And I think every prosecutor, I think everyone should have to read it, but I certainly think every prosecutor working on sexual offenses, it should be, mandatory reading. So for all those elected prosecutors out there, get a few of the books and start circulating them around your office, please. She didn't ask me to say that, by the way.
I did not, but thank you very much. Well, I really appreciate it. It means a lot coming from you in particular.
So I wanted to ask you to talk a little bit about what you discuss in the book and the invisible forces that warp credibility judgments. And in particular, I wanted you to elaborate on really interesting conceptual scheme you develop in the book called credibility discounting and credibility inflation. So can you sort of enter those concepts into our discussion?
Yeah, I'm happy to. So I view credibility as a form of power. We don't often think of it that way, but I believe it is. And credibility is not only a form of power, it's actually distributed along very familiar axes of power. So I'm going to state this as a general rule, recognizing, of course, that there are exceptions to every rule. But as a matter of course, credibility is discounted, and I'll explain more what that means, when someone comes forward with an allegation, particularly of abuse, and the allegation is made by someone who tends to be vulnerable or marginalized, particularly vis-a-vis the abuser. But any of these kind of identities that tend to be associated with less status in our society, less prestige, those are markers that are going to lead to this kind of discounting of credibility, which is really an unwarranted default to doubt, right? Rather than sort of consider all of the facts and the evidence in ways that are sort of as objective as we can possibly be as decision makers and evaluators. We have these myths that we've already started to talk about and misconceptions that shape the way we think about credibility. And so credibility discounting happens, again, most often when someone tends to lack social power. On the flip side, people who have quite a bit of authority and status in our society tend to get a credibility boost. Or, you can think of it as credibility inflation, which is that we don't tend to evaluate their often denials when it comes to sexual abuse allegations with the sort of skepticism that we ought to bring to the task, but rather we're more likely to believe, and we're very likely to care deeply about the consequences that would ensue if someone were to face accountability. So I want to take a step back and just complicate our ideas of what credibility is in a different way. So I've already talked about the dimension of power, but I also want to think about an allegation of abuse as involving not just the question of what happened, although it certainly involves that, but it also raises the question of who's to blame and do we care? And I think that thicker conception of credibility can also sort of enrich these ideas of discounting and inflation, because often, and I heard this often as a prosecutor, but also in the course of researching my book, often someone would come forward and make an allegation, and that person would be believed as to what happened. But the idea was that she was somehow to blame. And I promised I'd get back to the sort of perfect victim and how she behaves before an assault. I can tell you she certainly doesn't drink to the point of intoxication. She doesn't use any drugs. She dresses in a certain way and doesn't dress in other ways. And so when someone comes forward and makes an allegation of abuse, often, even if the decision maker, so to speak, the credibility evaluator believes that it happened, there's still a sense that there's blame on her part. And this is blame shifting, we call it victim blaming. We're pretty familiar with that, I think. The third dimension is care or concern. And I think this is a really important part of credibility too. When someone comes forward and says, this happened, and the perpetrator is to blame, I'm not, that person, she is often saying, and it matters, right? I want you to do something about this. It matters. And the response on the part of the person who's judging credibility is often, yes, it happened, but actually it doesn't really matter. It's not going to rise to the level of my care or concern. And I call this in the book the care gap. Right? It's the idea that there is this discrepancy between the care or regard that we tend to have for people who are more vulnerable, more marginalized, often women, particularly women of color, and then the care or the regard that we have for someone who is powerful, often a powerful man, often someone who is famous or otherwise has sort of the markers of prestige in our society. And there's a real gap there between sort of how much whether we're gonna treat the allegation with indifference. So, I think that you see this play itself out often in the context of what it referred to as he said, she said contexts, and the he said, she said contest, which can't be resolved, right? You can sort of almost see people shrugging their shoulders and sort of giving up on the idea that there's anything to be done about this. And in a he said, she said contest, invariably he wins, right? I think this is another way that you can see this discounting and inflation playing themselves out. So I'll stop there.
Thank you. That's really helpful. And I want to segue back to Anita and ask you about how some of these credibility concerns play out in the advocacy realm. So we've heard from Deb about how they often play out in prosecutors' offices, but in advocacy, what role does credibility play in determining whether someone is a victim of a sexual assault?
Ideally, it shouldn't play a role. It should be that the person comes forward, whoever they are, and says that they've experienced this criminal conduct perpetrated against them, and that's it, right? But we know that's not how the world works. And so in advocacy, it's difficult because you're sort of dealing with the court of public opinion. And so whatever your advocacy initiatives, your advocacy campaign is, if it's centered on one person, but you're looking at underlying issues of what you're trying to change or reform or transform, it still goes back to this person, whoever your opponents are in this advocacy campaign, theoretically trying to discredit the person who represents the face of the campaign, even though the campaign isn't necessarily about only one person's experiences. It is about what the underlying thing is what's the underlying system that needs to be disrupted and replaced and changed. And so if we're talking about someone who's a victim of a sex crime, and we're talking about whether it's sex trafficking or sexual assault, whatever it might be, it's for us within advocacy, what are the underlying policies that need to be identified and disrupted? So are we looking at the way service providers and law enforcement are not treating individuals coming forward in a trauma-informed manner? Are we looking at court procedures that need to be reassessed and maybe revamped and changed so that they're more person-centered? Are we looking at, I don't know if there's it sounds a little out there, but if we're looking at ICE workplace raids, And if you're trying to do, interviews with individuals that you're finding in the course of the raids, and they're women who are on tomato farms, and you're asking if someone's undocumented and they're working without a work authorization, and you're asking questions about, or people are coming up to you and disclosing sexual assault, like what are the underlying paradigms that need to be changed, instead of focusing so much on the credibility of the person. Like that comes from the other side when there's trying to be this like massive discrediting of whatever the underlying campaign is. And so for us on the advocacy side, it's always trying to bring it back to, these are the systems changes that we are trying to implement. And so yes, this person first, like, believe all people, believe victims. And then, and also just a note, like a quick tangential note about term victim. If someone identifies as a victim and they use the term victim in relation to themselves, we say victim. Some people say survivor. Some people say someone who has experienced, A, B, and C. So we use whatever language, you mirror the language of whatever the person is using to describe what they have been through. And everyone uses different language. But in advocacy, it's moving away from these conversations about credibility to bring it back to what the core issue is. Why is the reason this person came forward? What are they trying to change? What are they trying to identify and disrupt? And so we just keep bringing it back to that. But it can impact a campaign. It can be very sort of detrimental. And then you're having to fight on two fronts. You're having to engage in the systems change of the underlying issue. And you're also having to have the conversations that Deb has been walking us through in terms of why does the credibility, like the credibility is almost like a red herring in this situation, that it happened. We're not here to debate what happened. In the advocacy space, we're here to talk about what we can change moving forward.
That's really helpful. Thank you. So Jean, I want to shift back to you, and we've heard some ways in which these common misperceptions about the myth of the perfect victim play out, before, during, and after the assault or other crime, and it can impact prosecutors' perceptions of credibility, of course. So I wanted you to both speak to that if you have anything more to add on that front, but also maybe you could share with us your perceptions regarding how prosecutors have sort of evolved with respect to how they view these issues. Has anything changed, hopefully for the better?
Yeah, that's a great question. I do believe that my profession as a whole has changed. So I don't know that I need to necessarily rehash the things that necessarily impact the victim's credibility in circumstances like this, because they remain exactly what was in the drink, and how much ice was glass. We engage in silly discussions like that. But let's move to more to evolution, and kind of where I think in itself has gone to in I will say 20 years. Once I
Jean,
know
I'm just gonna interrupt you for a second. I think, Jean, I'm just gonna interrupt you for a second. I'm sorry. I think you're breaking up a little bit. So I think you started to break up a bit when you were talking about something being put in the drink, and then I think you were moving on to talk about how prosecutors' views have evolved with time. And so maybe in the bit of riffing that I just did there, your connection has improved such that the internet
I hope so.
Smile upon us.
I hope so. Is this better?
Yeah, it works.
Sorry. We're having some tech issues today. So I wanted to talk about the evolution, really, of prosecutors and how we have moved along, because I do think at one point in time during my career, early in my career, we required some things of victims to even get to the charging line, and that was we required some level of injury. We wanted to see an injury because we felt that gave us a much better chance of success inside courtrooms to attain convictions. But if you think about that, relatively few cases are going to make that mark. And what's enough of an injury? It's really letting perpetrators off the hook in a large quantity. other things that impacted credibility, where we have grown and evolved over time, is that the conduct of the victim was something we put a lot of energy and focus on. For instance, victims that were engaging in, for services, some sexual conduct as a service, that was just a no way. We would not have filed that case 20 years ago. Our views have greatly changed. And of course, that particular population is going to be find themselves in being a victim more often. So it's really important that we protect that group of individuals as well, and that they understand the doors to the prosecutor's office is open to them as well, that we don't want to discount those cases. It's important that they report, and it is important that prosecutors start their review as evaluators of credibility. There is no harm in starting with, I believe them. There's no harm in starting with that position. Now, that position cannot carry you through the court process. You have to evaluate it based on your laws, your facts, and the evidence that you have to carry it. But it is a much more of a trauma-informed approach to any victim that should walk through the doors of a prosecuting attorney's office. And that is, we believe you. And if you want to take it down to its most rudimentary level, we do believe people when they tell us they were victims of burglary, unless, we find out something different over time, that in fact, that was a false reporting. But we don't start at false reporting on burglary. And I know over time, we started at false reporting regarding sexual assault. And why any individual would report sexual assault when it didn't occur, one should ask that question first, because it's not a therapeutic process. The criminal justice process, it is not therapeutic. In fact, it can be quite the opposite of that. So I think it's for prosecutors to start in that space, give that same baseline that you give every other victim. That's still, I think, too short of a mark for us as a profession, but at least it's a place to start that's different from where we were once upon a time. And I hope that we continue to evolve in this space.
Thank you, Jean. So I want to pivot now to a different set of different but obviously related set of concerns, which is to highlight that the myth of the perfect victim has had a disproportionate impact on marginalized communities. And so I wanted to start with Anita at this point and ask you, which communities are most likely to be vulnerable to the negative impact of the myth of the perfect victim, and why do you think that is?
There's so many communities, unfortunately. So off the bat, I'm thinking immigrant women. So if you have immigration status issues, then you're not going to, going back to the beginning when Deb was talking about stereotypically what a perfect victim is expected to do, you're not going to report right away if you're undocumented. That's a huge one. If you experience sexual abuse or criminal sexual conduct at the hands of your employer and you're an immigrant worker, regardless of gender, you're not going to come forward and jeopardize your only economic lifeline and report that crime. So that's another, migrant workers are another huge community that don't come forward and report. Transgender, LGBTQ individuals, like we had a number of clients who were transgender, and there's still this, it's so outdated, but it still persists in some corners that individuals who might be transgender or are sex workers or are LGBTQ self-identified have this higher rate of promiscuity, which is not true. And so this is another very vulnerable community. Runaway teens. So we would work with underage individuals who were teenagers who, for a plethora of reasons, chose to leave their homes and they were housing insecure, which then creates more vulnerability for falling victim to particular crimes. Indigenous individuals, the rates of sexual violence against Indigenous, in particular Indigenous women, but not only Indigenous women, is much higher than the rate against the general population. And there are reasons for that, because there are often jurisdictional issues between tribal authorities and non-tribal authorities over who has jurisdiction once a crime has been reported. And so you have this sort of red tape back and forth. But those are some of the communities that are most likely to fall vulnerable to the myth of the perfect victim. Because there's so many other intersecting ways in which the multiple identities that these communities hold impact what they do and how they do it. And it doesn't jive with what mainstream society thinks you should do and how you should do something. And so we talked a little bit about immigration status. For individuals, for youth who had run away from home, if they reported certain crimes that they may have experienced, they'd have to interact with law enforcement. If they had a criminal history as a consequence of running away from home, then they could be detained or they could be incarcerated. And that's another reason why folks don't want to come forward. And if someone was a sex worker, that's not legal in most parts of the United States, except a couple counties in Nevada. So, there's so many reasons why people's simultaneous and intersecting identities prevent them from coming forward, which is what you think someone should do, or what society thinks the perfect type of victim would do coming forward, because you've experienced a crime. Of course, you're going to report it. You'll hopefully be believed, and there will hopefully be justice, whatever that means.
Thank you. So I was going to turn from Anita to Deb to ask her about how the myth of the perfect victim exacerbates disenfranchisement experienced by victims of sexual assault in marginalized communities. But I'll still pitch that one to you, but I feel like Anita did such a nice job of just unpacking a lot of those thoughts. I'll just ask you to add whatever you have to that set of questions.
Okay, sure. Yeah, building on Anita's great points. I think that to really understand the impact of, credibility discounting, we have to realize that it's system-wide and outside the system as well. So survivors anticipate the credibility discount, and that is often reason not to come forward. I'm not suggesting that's the only explanation for vast underreporting of sexual assault, but I think it's a really important component of this, rational calculus that it's so likely that I'm not going to have my allegation believed, or I'm going to be blamed, or I'm going to be dismissed. So I'm just gonna to keep quiet about it, or maybe only tell a trusted friend. Then we can think about credibility discounting as really operating throughout we're talking about the criminal justice system today. So, we can stay there, but, put in the back of your mind that there are Title IX proceedings on college campuses that are happening. There are workplace HR proceedings that are happening. And a lot of what I'm saying also applies to those contexts. In the criminal setting, we all know that there's case attrition. And I, want to be clear, I'm not just beating up on prosecutors here. I think all of us, whether we're working within the system or not, are impacted and shaped by these forces, cultural forces, law itself, right? It's not about bad apples. There are, of course, a few bad apples, but we're all sort of part of this culture that does this discounting. And so whether it's, law enforcement, police, detectives right at the outset, whether it's prosecutors, whether it's jurors and prosecutors thinking about jurors, whether it's jurors actually doing it, right? This is pervasive. It's not just at one stage of the criminal process. And so with all of that said, when someone comes forward, and maybe it's to a friend and discloses, right? And that friend validates the allegation, in whatever way the friend can, that is an act of empowerment. On the flip side, when someone is disbelieved, blamed, or disregarded, there is such a sense of devaluation that comes from that, and such disempowerment, because remember, credibility is a form of power. When someone doesn't get it, that disempowerment is only exacerbated. There's lots of psychological literature to bear this out. Psychologists have a term called institutional betrayal that I think is really helpful here. Not so much when it's a friend or family member, that's a personal betrayal, but we really invest our identities very heavily in our institutions. And when those communities turn against us and seem to value the perpetrator over the victim, right? That sends a powerful message about someone's worth, and it is very often experienced that way. So what I have heard over and over again from survivors is that the aftermath of abuse, the credibility discounting, was as bad as or even worse than the abuse itself. And I really ask people to sit with that for a little while, because it's staggering, right? We tend to think about the sexual abuse as just the worst possible thing. And I'm absolutely not minimizing the impact of sexual abuse, but it is because of the response on the part of the wider community when it's invalidating that I think for survivors, it can cut so deeply, and it can be felt as an expression, again, of sort of self-worth. So that's, I think, what the sort of disempowerment, I'm trying to unpack the disempowerment a bit and understand why this credibility judging is so critical, and it really implicates equality norms, right? And sort of people's equal status in a community or in our society. And the last thing I'll say about it is that, since we're talking to prosecutors here, the the prosecutor who represents, of course, the people, the state, can either validate or invalidate in ways that I think go far beyond even what sort of those smaller communities can do. So the stakes are really high here.
Thank you. That's I couldn't agree more with everything that just came out of your mouth. I wanted to turn to Jean now. So Deb sort of set this up, I think, appropriately, as a kind of systemic, cultural set of issues. It's not all just about what's happening in prosecutors' offices, of course. But I did want to ask Jean to reflect a little bit about what communities in your jurisdiction are most impacted by this myth of the perfect victim, and what steps, if any, has your office been able to take to address this concern?
So I think this is probably one of the areas that hurts my heart the most. That I think one of the areas that we judge generally more harshly than others are victims that have reported abuse before. They have reported sexual abuse before. And by the way, many marginalized groups of individuals will have had a higher degree of that kind of harm occurring to them. So for those who might be listening, who do this kind of work from a detective's standpoint, or from the standpoint of a prosecutor, just understand that you are going to encounter people that this is not the very first time that they have reported that they were victims of this kind of abuse before. It should not shock us. We should be prepared to know that, and be prepared to carry the evidence through in any particular case. So I just kind of wanted to say that, because of it. It seems to be one of the most harmful things that we can do is, if you've reported abuse before, sorry, we can't handle that. It's too much for us to be able to get you through this criminal process, because that's not true. So for those of us who manage organizations, it is also incumbent on us to do trainings to better understand who victims are and how to advocate for them in the criminal justice system, how to get cases through, how to build better cases so that we do a better job of building evidence in cases so that we can be more successful at trial. So again, this is not just about getting a case successfully to conviction. It is also about, how do we engage with victims that approach our office? Do we do it in a trauma-informed way? And every office should be doing trainings on what does it mean to be trauma-informed? What does it mean, to guide victims and their supporters through this process in a trauma-informed way? So I hope all offices are doing that basic level of training, but then also understanding in your own jurisdiction where are the marginalized groups, and do a better job of understanding them, especially if you don't look like them and you don't have part of your regular routine is not being a member of their community. So you've got to learn how to be a member of their community so that you can better represent them in the criminal justice process.
Thank you, Jean. So before we move on, not that we're leaving it behind, but before we sort of select another focus beyond the impact on people from marginalized communities, I wanted to wrap back to Anita to focus and maybe say a little bit more about a particular community of people who are especially impacted, people who are involved in trading commercial sex. As we know, it often goes underreported, and when it does come to the attention of law enforcement, it's rarely prosecuted. And not only is it oftentimes met with apathy, but also with abuse. So the extra layer of vulnerability there. So I wanted to just invite you to say a little bit more about that, and how can prosecutors in particular assist those who have experienced sexual harassment or abuse at the hands of local law enforcement? Sort of what's the prosecutor's role in that kind of situation?
Sure. So, well, historically, those who trade sex, so I'll use the term sex worker, but we're talking about the same thing, individuals who are trading sex, usually adults who are trading sex. They're treated as defendants in our criminal legal system, either because they have a criminal history for whatever reason, for whatever past experiences they may have had, or because the conduct they're engaging in while trading sex is itself criminalized, right? But how can prosecutors assist? One, believe the person who is coming forward. If someone is engaging in criminalized behavior and they're nonetheless coming forward to law enforcement and to prosecutors saying that they have been a victim of a sex crime, it goes back to something I think Deb said earlier, Deb or maybe Jean, who would come forward and say something had happened that hadn't happened to them. And so first, believe the person, validate and, support, validate and support their credibility. But then investigate to see what actually has happened here. I've had clients in the past who they had been victims of trafficking or sex abuse by law enforcement, and it was oftentimes covered up. So we would have conversations with the law enforcement entities and there was no investigation. And I know that I'm asking for something that's very, very difficult to do. And that is, there's like a lot of stigma around investigating law enforcement by prosecutors on behalf of some individuals whose credibility has historically always been a little bit tainted, right? Because of society's like norms and stigmas. But I'm asking like prosecutors believe, investigate, and then hold those accountable if you find someone or people have engaged in this kind of criminal conduct against those who trade sex.
Thank you. So I want to focus on kind of the nuts and bolts and practicalities of how the myth of the perfect victim really does play around in the criminal justice system. And so, Jean, if I can just start with you, prosecutors understandably are often very concerned about conviction rates. And, we would be naive to think that some of the factors that play into the myth of the perfect victim don't make it more difficult in reality to get convictions. But so I guess I just want to ask you broadly, how does this myth play into securing convictions in sex crimes cases, dealing with things like intoxication, drug use, sexual histories, anything that's considered sort of deviant or falling within this myth of the perfect victim? How should prosecutors consider these factors when they arise within a case?
So I will tell you, during my career as a prosecutor, the cases that I lost in the most frequency were these types of cases. They're hard and they're really heartbreaking to lose, because no matter how much I prepared victims going through the process with me, they almost inevitably asked, in that next meeting about what a jury decided. So they didn't believe me. They didn't believe me. And so I got better as a prosecutor being prepared, to handle those types of questions. And because often it's not quite that simple. They didn't believe me. Jurors often maybe didn't feel great about acquitting, but they still did it. So I think, it is something for prosecutors to weigh and think about the strength of your evidence. It's not fair for me to sit on a panel like this and tell prosecutors, just be tougher, just get out there and give it a try. That I'm not saying that. I think it is incumbent upon prosecutors to build a case that they do believe that they have a meritorious chance of succeeding, and that they're preparing their victim to go through that process with them. But if it's too light of an investigation, then make sure you shore up that case yourself. I can say from over 25 years in this business, I never was delivered a case by law enforcement that I felt like that's trial ready. So I had to do a lot of additional work to make sure, it was really ready to go and that I had adequate evidence. So keep looking for ways, to shore up the credibility of your victim, to shore up the evidence that is out there. Make sure you're going to get it. Make sure that you're getting phones, not just by the accused phones, but sometimes the accused and his circle. Make sure you're doing everything you can to build the case. And I will say, for maybe that higher level of prosecuting attorneys' offices, it does matter. It does matter when you are willing to take cases against those that are deemed more powerful, like a police officer. And man, it's critical that you find a way to carry those cases, because what we do does change behavior. Maybe not quickly enough, maybe not, in the quantities that we want it to. But prosecuting a bishop in my jurisdiction, I really do believe changed how the Catholic Church itself functioned in protecting kids going forward. I don't want to take all credit for that, but I do want to take a piece of credit, because prosecuting that particular bishop took a little piece out of me as well. They fight back in different ways. So I will just say, for the higher ends of, the higher management of offices, don't be overly scared to take on the powerful, because that can really, really shift the paradigm of who has the power in your community.
Thank you. Thank you. So Deb, I want to turn to you and ask a question about the relationship between sex crimes prosecutions and the phenomena of mass incarceration and racial injustice. How do you think about all of these concepts and put them together?
Yeah, it's such an important question. It's a really big question. It's a really hard question. So I'll throw in a few thoughts. One is to observe that the vast majority of sexual assault is intra-racial, the exception being Native American women who are more often raped by white men. But with that exception, when we're talking about sort of race and sexual assault, we're thinking about perpetrators and victims or survivors who are of the same racial group. And I mentioned that because I think for many women of color and Black women in particular, there are racial justice components to this notion that credibility discounting is so pervasive. And because women of color tend to receive the steepest credibility discounts, particularly when they are poor women as well, I think it's really important not to lose sight of that when we talk about race. Now, in terms of incarceration and mass incarceration, sex crimes are a very small portion of the problem, the very real problem of mass incarceration, particularly non-stranger sexual assault, which is what we've all been talking about today. That's what is the most common type, but that is not the type that the criminal system has tended to actually successfully prosecute, right? So there really is a very small number of cases that actually result in incarceration when we're talking about non-stranger sexual assault. But finally, what I will say is that incarceration for many survivors is not a particularly good metric of accountability. And I want to, take seriously the idea that there may be alternatives to incarceration that for some and maybe even most victims might feel better than the traditional path. And so we've seen restorative justice kind of growing in popularity, mostly on college campuses, but we're seeing some kind of innovative uses of alternative justice measures like restorative justice, even within the criminal system. And so I think we'll see more of that in the years to come, in part as prosecutors' offices become more survivor-centered in how they think about prosecution and sentencing. Yeah, so I'll stop there.
Great, thank you. So Anita, if I can, I want to combine two questions that I was going to ask you, drawing both on sort of the nuts and bolts of how the criminal justice system works, and then also partnering with local organizations to provide support for survivors. So what sorts of supports from your perspective, both during trial and during the sentencing process, can be most helpful for victims of sex crimes? And how can prosecutors' offices effectively create those partnerships with community organizations to make sure that survivors are getting the support that they need and deserve?
Yeah, thank you. So some of the supports that I will list off are childcare. Childcare is a huge one during trial and sentencing. So we had clients who would have kids, whether they were US citizens or immigrants, and they have kids, and you need to take care of your kids. Transportation is another one. So transportation to and from the courthouse, explaining in detail, accessible detail, exactly what is going to happen, what the person can expect during the trial, during the sentencing. Information is power, and you already have a power imbalance and power dynamics that are at play here that Deb has talked a little bit about from the credibility perspective. But when people have information as to what they can expect and what could happen or is likely to happen, that makes a big difference. We also had clients who needed to have like meaningful access to interpretation. So clients who don't speak the main language of whatever the court proceedings are happening in, they need to have interpretation, credible, good interpretation. Not all interpretation is good, so you need to have good interpreters. For sentencing, it was important for a lot of our clients that they had the opportunity to provide a victim impact statement, and so that they have support in providing those victim impact statements, either with the ADA that they were working with, or the social workers that either were coming from the community organizations that I'll talk about, or the social workers that may have been embedded within the prosecutor's offices. Access to counseling is a huge one. So this is a very traumatic experience for anyone. Now imagine you've experienced sexual assault and now you have to go to trial. And so sometimes it can feel like you're the one on trial as opposed to being the witness who's testifying to something that happened to you. And so having access to sustained, reliable, good therapeutic counseling is super important. And also advocacy with employers. A lot of our clients worked and the employers were not always understanding of the client needing to take time off of work to participate in the trial or to take time off work to go to sentencing. And so whatever advocacy or intervention the prosecutorial offices can do in terms of supporting the victim witness for getting time off work, compensated time off work, that's really important as well. So how do we create partnerships with community organizations to ensure that these supports are being provided? So make a list of all of the community organizations that are working with these populations. So not just sex crime survivors, but organizations that are working with immigrants, organizations that are working with Indigenous folks, that are working with LGBTQ individuals, that are working with these populations, because the populations have experienced sex crimes. So you don't have to look for only, or don't limit yourself only to organizations that are working with victims of sex crimes, but organizations that are working with the populations, generally speaking. Do meet and greet with those organizations. So when I was at Safe Horizon, we had the NYPD unit that worked on human trafficking come to Safe Horizon, meet with my staff in person, develop these interpersonal relationships so we could determine how we support the clients and how they support from their perspective. And so develop these interpersonal relationships. Visit the offices, not in uniform. Do not come in uniform. It is very traumatizing for anyone, any clients who may be there to receive social services. And get staff feedback and input. So meet with the community organizations and say, how can you as prosecutors better support this shared pool, the shared demographic of clients? And to create partnerships, make sure that you are retaining the type of staff and hiring the type of staff that you need to have. I think that's going to be a future question, but really develop these strong interpersonal relationships with community organizations and get their feedback on the practices and procedures you need to implement within your own offices.
Thank you. And because of time, I'm conscious of the time. I know we want to break at 2:15 to take some of the questions that have been posed. I think I may skip to the lightning round, and that hopefully will provide anyone an opportunity to sort of say the thing that I didn't ask about yet. So I'll just start. I'll go Jean, Deb, Anita, and I'm going to ask you, what advice would you give to prosecutors who want to better serve survivors of sexual assault crimes? So let's start with Jean.
You know, we've said this a little bit already before, so I feel like I might be repeating, but as an assistant prosecutor, start by believing this person that comes to your office. It doesn't cost you anything to do that. Learn what it means to provide trauma-informed care and support to all victims as they come through your office, but especially these individuals and those that have been more marginalized by the system as a whole, meaning the system hasn't probably been there for them, to be an answer to their harm in the past. And then if you're an assistant prosecutor, make sure you're advocating for proper training. Make sure you're sending those requests up your chain, however you need to do so, that says, I need this type of training. And I will tell you, in my office, that has happened on issues of strangulation, where we were able to evolve pretty greatly by an assistant prosecutor telling me this is a type of training we all would benefit from. And we did. So make sure, as if you are a prosecutor that's leading an office or leading a unit, make sure you're forming relationships with those community organizations that are going to help you fill in the gaps where you can't, with other types of services for counseling, perhaps childcare, other forms of advocacy. So mostly that.
Thank you, Jean. So Deb, I will pitch it to you. What advice would you give to prosecutors who want to better serve survivors of sexual assault crimes?
I thought those are great ideas, and I guess I'll plus one. But to say something different, maybe not by way of advice, but hopefully by way of sort of helpfully thinking through what prosecutors can do to dispel the myth of the perfect victim. I'll come back around to Harvey Weinstein, which is where we started. One really, I think, important aspect of the trial that's been overlooked is the use of the sex crimes expert. This was someone who did not pathologize any of the women who came forward. There was no testimony about so-called rape trauma syndrome. But what the expert did do was testify about common behaviors on the part of victims of sexual assault. I think this is a really important innovation. It's not that it's, completely new, but we're seeing it in some of these high-profile prosecutions. There's really no reason we shouldn't see it more often, and that it shouldn't be a way for prosecutors to be able to move forward, even in the absence of lots of, other acts of witnesses. Maybe this is a person who hasn't assaulted dozens of people. Maybe your evidence rules don't allow you to get it in. This is another way to go at the credibility discount. And I think it's a really important prosecutorial tactic that has been often overlooked. So I have a law review article, which is a little bit wonky, but also I think pretty practical in its approach. And if anyone is interested in thinking about sex crimes experts, I'm happy to send it your way. So you can shoot me an email and I'll get that to you. So sex crimes experts.
Thank you. Okay, Anita, you can take us into Q&A by offering any advice that you would give to prosecutors who want to better serve survivors of sexual assault crimes.
Solicit recommendations and policy guidance from impacted communities. So those who've experienced sex crimes, those who are advisors for community organizations, those who are paid staff at community organizations, solicit impacted communities for their recommendations and pay them for their time and expertise.
Excellent, thank you. So we have a number of questions here. Rachel, is it okay if I just sort of go into them and pick and choose to get a
Absolutely.
variety of? Okay, so I've sort of been trying to do this and see what's coming in. So I think I'm going to start with a question from Michelle Lopez. It states as follows: would you agree that in addition to being victim-centered with interviewing the victim or survivor to validate their credibility, that it would be equally important to educate the judge and jury from the start of jury selection through opening and summations, so with experts, as Deb just mentioned. But I think this is helpful insofar as it opens up the opportunity to talk about how prosecutors can talk to judges, can talk to juries, to really start to dispel some of these myths during the trial process. So maybe I'll start. Well, I'll just let anybody jump in who wants to.
I'll jump in. This is Jean taking this one. Look, jury selection is critical. I think even before you walk in the door for jury selection, it's critical. Never lose an opportunity to try and make the points that you want to make, to humanize all of your witnesses in your case. That's just, step one. You never, ever lose an opportunity. In all those pretrial motions that you should be filing and that you should be fighting for or against, depending on what the issues are. Never, ever lose an opportunity to advocate the positions that you think are misunderstood about your case and how to advance, the overall work of what we're trying to achieve here.
Yeah, the only thing I would add is, of course, everything that we're saying today is that you sort of should be coming into this thinking about your juror pool as having a tendency to discount the credibility, and again, particularly of marginalized victims. But I will also say, maybe on a more optimistic note, I also believe that these high-profile cases, however they're sort of turning out, do have an educative function on your jury pool. And I would, while being, very proactive about the kind of educating efforts that Jean has talked about, I also think we're seeing some change and that people are coming, I believe, to the task of judging credibility and hearing these cases differently than they were 5, 10 years ago. So, maybe a little bit of optimism from someone who's not particularly often optimistic.
Thank you. Anita, did you want to jump in or should I go to the next question?
You can do the next question.
Okay, great. So the next point I wanted to raise in the Q&A, I don't know if it's so much a question, but it's just, I want to give it a chef's kiss. I'm really enjoying reading this one from Todd Collins. So I'll read what was written here and then ask if anyone wants to comment on it. So Todd writes, I've been prosecuting these cases for more than 20 years. Several years ago, I decided to reframe what winning a sexual assault case means. If a victim takes the opportunity to stand up for herself and speak her truth, to stand up to her assailant and let him know that she knows what he did, he knows what he did, and that it will never happen again, she's bringing light to a dark situation. Then the verdict doesn't matter. The DA believes her because she's now a survivor, and if the jury sees it our way, that's great. If not, so what? The verdict is secondary. Of course, knowing that we have to go forward ethically with a good faith basis that the jury would be justified in convicting. But the basic idea here, I think, echoes some of what Deb was saying earlier, that really it's the prosecutor's responsibility to show the institutional courage to go forward when they believe the victim. And so that's certainly the way that I was taught when I was a prosecutor. I was taught that your job is to get this past directed verdict, get it to the jury. If you get a good case to the jury and they acquit, you've done your job. So I'll just throw it out to the group and see if anyone wants to jump in on that.
Yes, I totally agree too. And thank you for formulating that in such a powerful way. Many of the survivors I have spoken with over the years have made clear that, sort of how the case was handled was critical. And ultimately, people understand the burden of proof beyond a reasonable doubt and how high a burden that is. Not in every case, but in many, many cases, having that opportunity to have someone take the case forward and believe in it and believe in the survivor is deeply, deeply meaningful and can have a very empowering effect.
I'll just add to the comments that have already been made that I want to thank someone named Todd who's been doing this kind of work for 20 years, because you're not generally the kind of person, prosecutor I've seen that does that kind of work for 20 years. So thank you to everybody who does that kind of work, but to the Todds. Good question, good answer.
I'll add that, for some of our clients, maybe they couldn't like fight back at the time, but they're fighting back during trial, right? So maybe a few years later, maybe they needed that time, that detachment from whatever happened to give them to make them ready to fight. Maybe that was their way of fighting back now, right? It was a trial. And so even knowing it was potentially going to be an uphill battle, the clients are like, well, I don't want anyone else to go through what I went through, and they're not going to get away with it. It doesn't even matter. For some people, it didn't matter what the verdict was. It was that they were going to speak their truth, and that was the most important thing.
So I'll take a question here from Jennifer Jarrett asking, what role do prosecutors have in making sure that law enforcement has trauma-informed training? I'll jump in if nobody else will. And I mean, it's different it's difficult, I suppose, in the sense that these are different offices and there's different chains of command and often different budgets. So there's only so much one can do when one gets, as Jean said, a file that is not ready for trial. And oftentimes in these sorts of cases, it's not ready for trial because a proper investigation hasn't been done, because investigators have not started by believing, they've started by discounting and falling into all the problems we've identified today. But at the end of the day, the prosecutor has the right to go back and say, we need more, we need to do better. And so what I've seen over the decades I've been working on these kinds of issues, both as a prosecutor and as an academic, is the prosecutors sometimes saying, and I would say too often saying, we can't go forward because there's just not enough evidence. There's just not a good enough investigation hasn't been done. It's like, well, maybe you could do something about that. What have you done to ask for a better investigation? You may not be able to sort of structurally have the power to enforce it, but certainly, maintaining a good connection with your investigators, depending on the setup, if you can do supplemental investigations yourself. Perhaps Jean can speak to how that works in your jurisdiction. Do you have investigators in your office that can do follow-up, or is it a matter of sort of trying to persuade the police to do follow-ups?
In my jurisdiction, it's a little bit of both, but I probably got maybe a little close to the line at times on trying to get a case. I thought thoroughly prepared at the level I believed it needed to be. So I did some kind of work myself, trying to get police to come along with me. I do have some investigators in this office that also can assist with that. So that can be a little bit of a balance. But I'll offer one other context of how this can be done. One of the individuals in my office started a roundtable where investigators were present at the table, where prosecutors and law enforcement talked about a series of cases. And the goal was that both sides could see, what the struggle was, through an investigation, what were some of the key issues that continued to come up in prosecution that we didn't feel like we could overcome. And so that roundtable does offer an opportunity. We're talking about a fact-specific case. how prosecutors think it could get there if additional work were done. And I think law enforcement benefited from seeing overall, a variety of cases and how some, were stronger than others in its investigative realm. So I think that roundtable kind of no finger pointing kind of process really does help aid both sides in getting to a successful case.
Great. So I think we have time for at least one more question, and I'm going to take one that asks about the issue of mass incarceration and racial injustice that we touched upon previously. Do you find that these issues shape how women of color view accountability of perpetrators in intraracial sexual assault situations, and may impact their reporting or their sort of staying with the prosecution throughout?
Absolutely. And I have a large portion of the book that's devoted to just this dilemma that many women of color and Black women in particular face in, deciding whether law enforcement is a place to turn. So, in addition to what we've talked about already, mass incarceration weighs heavily in the calculus, and the idea that the community will sort of see this as an act of betrayal is something that many Black women, Anita Hill in particular, has written about really powerfully. And so I think we just can't understand this problem without thinking about mass incarceration. When I say this problem, I really do mean kind of the dilemma that a woman of color who's been sexually assaulted faces in deciding whether there's any sort of path to criminal justice.
Did anyone else want to jump in on that? Or I have one more question perhaps we have time for. And this is from Julia Reitz, the elected state's attorney from Champaign County, Illinois, where I was a baby prosecutor, and who deserves credit for what I'd said previously about how I was trained up when I was younger. So she owes credit, or I owe her for more than just that. But we'll end with her question. So Julia asks, what weight do you give the trauma that the process can cause to the victim survivor in making the decision to prosecute a difficult case?
I'll try that one. It's case specific, fact specific, but it does matter. In my opinion, it does matter, because when you're taking a case like this to trial, through deposition, through cross-examinations, it can be very, very hard. Even when you prepare victims for the potential of an outcome that's not what you're seeking, it still can be very traumatizing, and it depends on whether or not that you can help that particular individual have additional support services. Maybe you can get them, even somebody who doesn't seem quite ready to handle a very contentious process. But the truth is about our system is that it's adversarial, and that puts these particular victims really in the crosshairs often. That doesn't mean that we should be fearful of taking them with us, but it does mean we should be mindful of taking them with us and what we can do to help support them with other resources so they can get through this system unharmed. I sure as hell don't want them to be harmed by the criminal justice process. So it is a factor for me, but I would say it's depending on my individual facts in front of me.
Anita, did you want to jump in on that one?
It's tough because I think we've had clients who they're like so broken down. They're so emotional, like, but I want to move forward. And sometimes, my social workers would say, are you sure? Are you sure? And it's people are more resilient than we think they are. People are very, very resilient. And yes, people have been through some really horrific, like unimaginable things. But if we're believing someone when they say they've been a victim of sexual assault, then shouldn't we also believe the person when they say that they want to move forward and they want to do it no matter what other, things may be at play? And it's just giving the person the agency to move forward and to make their own decisions.
Thank you. So I see Rachel's back with us. I will pass it back over to Rachel. Thank you all very much. It was a great honor to participate in this conversation.
Thank you so much, Professor Dempsey. Thank you all to our panelists. You were wonderful. We wish we could continue this conversation, and the IIP will continue to host similar conversations and provide resources on this important issue. But I really want to thank you for your willingness to participate and share in today's discussion, and want to thank everyone who came and watched. We will be posting this video online shortly, and so you'll be able to watch it if you missed it or want to share portions of it with other folks in your offices or beyond. So thank you so much to all of our panelists and to Professor Dempsey for moderating, and we will see you next month at our monthly webinar. And if you're not signed up, prosecution.org, you can sign up for all of our webinars, and we'll see you next time. Thank you.